A very good morning to all my dear students and listeners. Today we are going to discuss about drafting of notice under Section 106 of Transfer of Property Act 1882 under the subject captioned as drafting, pleading and convincing. My dear students, as you all are aware that this particular topic is provided under unit number 4 of the Guru Gobind Singh Indraprastha University syllabus. As such, to start with today's topic, I just want to recapitulate the law relating to Section 106 of the TPA, which provides for termination of tenancy. So my dear students, let's start with the same. As far as Section 106 is concerned, the law provides as under. Section 106 provides that for termination of a lease, a notice has to be given to the other side, that is the landlord or the tenant, as the case may be. So it provides that duration and how that time period is to be calculated. So it provides that duration of certain leases in absence of written contract or local usage, meaning thereby Section 106 would be applicable in those cases where there is no written contract or where there is no local usage. Section 106 clause 1 provides that in the absence of a contract or local law or usage to the contrary, a lease of immovable property for agricultural or manufacturing purpose shall be deemed to be a lease from year to year, terminable on the part of either lessor or lessee by 6 months' notice, and a lease of immovable property for any other purpose shall be deemed to be a lease from month to month, terminable on the part of either lessor or lessee by 15 days notice, meaning thereby in the case of the agricultural lease, a 6 months notice needs to be given, or for manufacturing purpose. Further, if it is a lease of an immovable property for any other purpose is concerned, then it shall be deemed to be a lease from month to month, and which is terminable on the part of both the parties by giving 15 days notice. Further, it provides that notwithstanding anything contained in any other law for a time being in force, the period mentioned in subsection 1 shall commence from the date of receipt of the notice. Clause 3 provides a notice under subsection 1 shall not be deemed to be invalid merely because the period mentioned therein falls short of the period specified under that subsection, where a suit or proceeding is filed after the expiry of the period mentioned in that subsection. Further, clause 4 provides that every notice under subsection 1 must be in writing, signed, or on behalf of the person giving it, either be sent by post to the party who is intended to be bound by it, or be tendered or delivered personally to such party or to one of his family servants or servants at his residence, or affixed to a conspicuous part of the property. So, my dear student, from this we may infer that following essential needs to be looked into while drafting a notice under section 106, and these are that first you have to look at the aspect that whether the lease is for agricultural purpose or for manufacturing purpose or for any other purpose. Further, the lease must be of an immovable property only. It does not speak of movable property. Further, if it is a case of agricultural or manufacturing, then you have to serve the notice to the other side for 6 months. And if it is for any other purpose not covered under agricultural or manufacturing purpose, then it will be determinable by 15 days notice. And this 15 days notice or 6 months notice would be commenced from the date of the receipt of the notice. Further, what would be the effect if this particular time period, that is 6 months or 15 days, has not been adhered to? The effect of this particular thing or aspect has been provided under section 106 clause 3, which reads as under: a notice under subsection 1 shall not be deemed to be invalid merely because the period mentioned therein falls short of the period specified under that subsection, where a suit or proceeding is filed after the expiry of the period mentioned in that subsection. Further, notice must be given in writing. It must not be given orally. It can be signed by the person, either the lessor or by the lessee or by their counsel. And this notice needs to be sent to the other side, either by post or be tendered to one of his family members or to his servant. As you all are aware, similar provision is given under section 64 of the CPC and CRPC as well. At his residence, or if such affixed to conspicuous part of the property. So this similar provision is provided under Order 5 Rule 20 CPC and 64 and 65 of CRPC. So my dear student, please bear these essential elements to be kept in mind for drafting a notice under section 106. So let's start with the drafting of the notice under section 106, wherein I would provide you the format for preparing or drafting a legal or a notice under section 106 of TPA. As you all are aware that a notice must have a date and also a description. And the description, you may write it as notice under section 106 of TPA 1882. Further, it must be a date. Second, the said notice must also have an addressee, where you explain the addressee by his name, his father's name or son's name, as the case may be, and his place of residence. Further, it must also have a subject. Then you may write as notice under section 106 of the TPA. Thereafter, you will explain about your client, who is your client. Thereafter, if this particular notice has been served through an advocate or on behalf of by an advocate on behalf of his client, then you may write under instructions received from and on behalf of our client above named, we do hereby address you as follows. Further, you may explain the facts as below mentioned. The portion of the second floor of the property bearing number so and so, measuring so and so, has been let out to you for commercial use, and you are holding the said portion as a tenant under our client at the rate of rupees so and so per square feet, aggregating to rupees so and so per month only. Second, the tenancy in your favor was for dash year and has expired on so and so, but you have not handed over the vacant and peaceful possession of property bearing number so and so, measuring so and so to our client. So these are the essential facts wherein you are mentioning that and explaining about this property in question and the purpose for which that particular property has been let out to you. That means that is to the lessee. Further, you will have to explain that the tenure of the tenancy has expired, and even after the expiration of the duration of the lease, you have the tenant, the lessee has not handed over the peaceful possession to the owner thereof. Further, as our client, who is the owner, is no longer interested in continuing with the tenancy with you noticing, we at the instance of our client do hereby give notice that your monthly tenancy in respect of the property bearing number so and so shall stand terminated upon expiry of 15 days from the date of the receipt of this notice, meaning thereby as contemplated under section 106 of the Transfer of Property Act. My dear students, that this is a case of any other tenancy other than that of agricultural or manufacturing purpose. So you have to serve a minimum notice of 15 days to the other party. So in this also, the notice of 15 days has been given. We, on behalf of our client, accordingly call upon you to quit and vacate and deliver up the peaceful and the vacant possession of the property measuring so and so and bearing number so and so upon expiry of 15 days notice from the date of the receipt of this notice to our client. In the event you fail to quit, vacant and deliver up the vacant and peaceful possession upon expiry of 15 days from the date of the receipt of the instant notice, you will be treated as a trespasser, and appropriate legal proceedings against you would be initiated for recovery of vacant possession, measuring so and so and other relief. Needless to mention that you will be responsible for the cost and expenses thereof. So you have to apprise the other side, that is the tenant, that if he is failed to deliver the possession within a stipulated period, then in that case, he will be treated as a trespasser, and appropriate legal proceeding under the relevant statute or under the relevant law, he will be prosecuted thereafter, and the same would be occurred at the cost and expenses of the tenant itself. Further, you may write as, please treat this notice as a notice under section 106 of the TPA. Thereafter, that notice needs to be signed by an advocate or by the party as contemplated under section 106 of clause 4 of the TPA. And thereafter, you will have to retain a copy of the notice with you at your office. So you may write it like, a copy of the notice has been retained in my office for future records. So my dear students, this is all about today's lecture. Hope you have learned a lot out of it. In case of any query, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's lecture, I just want to apprise you with my new topic, which I am going to take in my next class or next lecture. And my new topic would be on drafting of notice under section 80 CPC. As you all are aware that section 80 relates to government suit. So as per law, before filing a civil suit under section 80 against the government, then the party who wants to sue the government has to serve a notice of 2 months before filing or before instituting a civil suit against the government, which I would like to explain in my next lecture. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.